We have been sent to protect us, to defend. Let justice flow like a river. Good day, Council. Good day. Hope you're fine. Welcome to Conflict of Laws. As always, I am your tutor, Council Felipe. Now, before we get into the nitty-gritties of the course, I would like to outrightly mention to you that your understanding of conflict of laws is reliant on your understanding and application of general principles of law, such as the law of contract, the law of tort, jurisdiction, and so many more. It will also require you to record your understanding of international law as a whole. International law, as a course that you did last semester, is what we refer to as public international law, whilst conflict of laws is referred to as private international law. So we'll get into the main course of this particular recording, so as to draw out the various parts of the course that you need to understand as far as your learning is concerned. Now, let us get into the lesson. Conflict of laws is also called private international law. It is a body of rules and regulations whose purpose is to assist an English court in deciding a case which contains a foreign element. This basically means that conflict of laws as a body of law only becomes relevant if, in a case that is being decided by a court, a foreign element comes to light. Lord Parker, in Dynamite Action Gasoshaft versus Rio Tinto Limited, stated that every legal decision of our own courts consists the application of our own law to the facts of the case as ascertained by appropriate evidence. One of these facts may be the state of a foreign law, but it is not the foreign law, but our own law to which effect is given. As has often been said, private international law is really a branch of municipal law, and obviously there can be no branch of municipal law in which the general policy of such law can be properly ignored. So this quotation by Lord Parker is one that talks about the nature and status of private international law, or conflict of laws as we know it. It is considered to be part and parcel of municipal law. It is not law that regulates countries, as you will see later on. The principles of private international law or conflict of laws only come to light where there is a clash between two different legal systems. Your general understanding of the law or a legal system is that it protects the interest of the people who are within the legal system. Thus, the application of laws and principles is only relevant in the safeguarding of the interests of the people within a particular jurisdiction. Thus, when you're determining the application of conflict of laws, you're basically looking at the application of laws within the jurisdiction to protect the interests of the people concerned or the parties to the case. Now, in a situation where these people in consideration or the issues being decided herein brings in two different legal systems protecting two different principles, leading to a conflict or a clash of the interests that have been protected, resort is made to conflict of law rules in determining exactly what law is going to be applied, or what principles are going to be decided, and all of those things in order to ensure that the interest of the parties who are concerned with the case is safeguarded. So the foreign element is what brings the two legal systems to a crash, that's requiring recourse to be made to the conflict of law rules in an effort to determine the matter. So this is basically what I am from saying. If you have two different legal systems coming to a crash, the crash in itself is what we're calling the foreign element. So for example, in a situation where there's a transaction, a commercial transaction that is being discussed in a matter, it might be that in one area of the law, the formation of the contract is considered to not have happened. And in another area of law or another legal system, we're saying there's no regards to basic principles such as offer and acceptance to be considered in the formation of a contract. So in this situation, the parties who are part of that particular commercial transaction now have to determine whether or not there was a contract, and if there was such a contract, the conferment of rights and obligations are placed on the parties to that particular transaction. So now this is what conflict comes in to do. In as much as there are two different legal systems saying two different things, the court should not just fold its arms in determining the matter. It should undertake initiative to ensure that the interests of the parties to this particular commercial transaction are safeguarded and protected. That is what we're calling the foreign element. That is what we're calling what is exactly is conflict of laws. Okay, so the conflict of laws as a course is as three divisions. There's jurisdiction of the court and related principles, choice of law rules, and recognition and enforcement of foreign judgments. These are the three divisions of conflict of laws. We'll consider all of them as we delve deeper and deeper into the course. But before we go anywhere, we need to ascertain and distinguish private international law from public international law. Now, the 5 considerations that you're seeing on your screen right now are what are taken to be the distinguishing factors for public international law and private international law. These are the differences. Number 1, in relation to scope, we're saying public international law governs the relationship between states and international organizations. If you remember your international law very well, you're going to discover that the two that I've mentioned here are what are called international persons, or persons with an international personality. In private international law, it is a resolution of disputes between private individuals, between individuals and corporations. This is what it is trying to look into. Private international law is basically a resolution of conflicts. And these conflicts are conflicts that are existing between two legal systems or different legal systems coming to a crash.
26076088619.
Apologies. That someone called. Okay. So that's the scope. Private international law deals with the resolution of disputes between legal systems. Disputes between legal systems. Whereas public international law regulates the relationships between persons of international capacity. That's the distinction as related to scope. In Conflict of laws, as we're talking about right now, we're dealing with the conflict of two different legal systems or just different legal systems, because it might be more than one, it might be more than two, it might be three, it might be four, depending on the issues that are to be determined in the case and the case in consideration. Then we have subject matter. For public international law, it is dealing with issues of global concern, such as diplomatic relations, human rights, and so on and so forth. For private international law, we are dealing with matters addressing individuals, corporations, and other private entities, such as contracts, such as tort law, such as issues of jurisdiction, recognition and enforcement of foreign judgments. Those are matters that are specifically to individuals and not necessarily issues of global concern. So here you might say that conflict of laws is primarily dealing with private matters, whereas public international law, it is dealing with issues relating to the public as a whole. And the public here is not in relation to the domestic consideration of what public is, but it is dealing with the consideration of what exists in the international community and what the international community regards to be public issues. And the issues that have been cited there as examples can be cited as examples to elaborate on that particular issue. Issues relating to diplomatic relations, consular relations, human rights, laws of war, all of these are laws of war, that is use of force rather, that is, or public international law. But for private international law, we're basically talking about private issues that are just specifically to maybe 2 or 3 people who are involved in a crash, maybe and instead of using people, use persons, so that we equally encompass corporations. So things like contracts, things like protection of IP, yeah, intellectual property, and so on and so forth. That is all private international law. They are private matters between 2 or 3 people, and that's, as I said, not necessarily the whole public or community as a whole. Then we have the governing law. What exactly is sourcing this area of consideration under the law? Public international law, of course, as we already know, Article 38 of the International Court of Justice Statute prescribes for the sources of public international law. The sources of public international law include treaties, it includes international customs, it includes judicial decisions, and all of those things. They are all in Article 38 of the Statute of the ICJ. Now, that is where we get public international law from. Where do we get private international law from? We're basically saying, like I earlier mentioned in the introduction to the course, that private international law is domestic in nature. Thus, these principles of private international law are from domestic laws. Now, will you continue listening to me talk about the English courts, the English courts, the English courts every now and then, but this is only done because private international law was actually founded in England, and it is based off principles that are applicable in England as well as any other country. Of course, each and every country will have specific and unique principles relating to conflict of laws. Just like Zambia has its own conflict of laws principles, Congo has its own principles, and England has its own principles. Here we're talking about the general principles of conflict of laws. So there will be specific areas of regulation as far as conflict of laws is concerned. Just like at the end of the course, we're going to talk about recognition and enforcement of foreign judgments with regard to Zambian law. So every country that is in existence here has principles and rules and regulations that govern private international law. So even here, the source is domestic law, because that is how a conflict of laws is considered, not necessarily laws that are regulating the whole international community as those that are highlighted and recognized under Article 38. Then compliance.